The next panel to share is John Fogarty. John is a senior associate. Everyone hear me clearly? He's a senior associate at Corrs Chambers at Westgarth, where he works in the litigation practice group. John has worked for a range of government and corporate clients in a variety of proceedings in the county court, Supreme Court, and federal court. John has a particular expertise in the area of trade practices enforcement and has acted for the Australian Competition and Consumer Commission in numerous federal court proceedings, including the successful 2011 contempt application against Allergy Pathway and its sole director, one of the first Australian cases to consider social media users' liability for third-party posts. John wrote a piece about the Allergy Pathway case for the Law Institute Journal, for which he received the 2012 Rogers Legal Writing Award. John's article is titled "Beware of the Social Network." John will now discuss one's liability for misleading statements on commercial entities' social media pages and profiles. John?
Thanks, Hassan. So I'm going to talk about your liability for posts that other people put on your social media pages. So by way of example, if Bill were to post a defamatory statement about me on Leigh's Facebook page, I would have a cause of action against Bill. But would I have a cause of action against Leigh? To explore this topic, I'm going to talk in some depth about the Allergy Pathway decision, which is a federal court case which, as Hassan said, I was involved in and have written about. And that really concerns this scenario. I'm then going to talk briefly about the developments since that 2011 decision. So turning first to the Allergy Pathway case, and turning first to the first part of that case, because there's two judgments in that proceeding. There's the initial ACCC proceeding, which was under the Trade Practices Act, in which the ACCC alleged that Allergy Pathway had made misleading or deceptive comments. Allergy Pathway operated clinics purportedly for the diagnosis and treatment of allergies. The techniques were not medically validated, and obviously the 2009, around that time where there was a lot of research about the prevalence of allergies recently, and the risks of relying on unproven treatments. So there was a real concern about this kind of conduct. So in early 2009, the ACCC commenced a proceeding against Allergy Pathway and its sole director, here, concerning alleged false and misleading representations that Allergy Pathway could, for example, test for allergens, or could successfully treat allergies or cure allergies even, which is something our experts have said you couldn't do. That initial proceeding was resolved by consent. Importantly, the relief included undertakings. Allergy Pathway undertook not to publish the same or similar representations for a period of 3 years, and Mr. Keir also undertook that he would not be in any way involved in the making of or the publication of such representations. Had it been left at that, it would have been a fairly unremarkable case, and I probably definitely wouldn't be talking about it to you today. But of course, it didn't end there, and in 2011, the ACCC made a contempt application against the ACCC and Mr. Keir, alleging that in contempt of court, Allergy Pathway had made numerous representations that breached that undertaking. The allegations related to numerous representations in various categories of representation. So some of them were direct statements by the company about what it could and couldn't do. But important, and those were all fairly, there wasn't a lot of contest about those types of representation. But importantly, those representations also included testimonials that were written and posted on Allergy Pathway's Facebook wall. So this is where the controversy came in this otherwise unremarkable case, because Allergy Pathway and Mr. Keir said, okay, I can be responsible for things things that I post on my Facebook page. I can be responsible for the things that I publish on my website, but I shouldn't be held responsible for statements made by my clients or Facebook friends. So the big issue for Justice Finkelstein of the Federal Court was, did Allergy Pathway publish those testimonials? Ultimately, Justice Finkelstein found that while Allergy Pathway was not responsible for the initial publication of those testimonials, it had assumed general responsibility for the postings because it, first of all, knew of the postings, knew that they were untrue because the involvement in the first proceeding was undeniable, and the undertakings were there in black and white. It was also clear that Mr. Keir had some activity on the Facebook page, so he'd obviously seen it. The court was happy to infer that he had seen it. Secondly, Mr. Keir and Allergy Pathway had the power to remove those posts. That's something that all Facebook users have, the power to remove posts that they don't like or for some reason they want to take down. And then thirdly, he took no steps to take down those posts. And in those circumstances, Justice Finkelstein was prepared to find that he had assumed responsibility for those posts. Justice Finkelstein went further and inferred that Allergy Pathway didn't remove the testimonials because it wanted the benefit of the praise for those services or the legitimacy that the testimonials might have added to the business. So what was the immediate outcome of that decision? Well, it truly was a social media disaster for Mr. Keir and for the company. It was a contempt application, so there were fines and penalties. The fines weren't huge. I think they were less than $10,000 total. But he was also ordered to pay costs on an indemnity basis because it was a contempt application, and those costs were not small. There was also a lot of negative publicity, and ultimately all those things came together and ended the business altogether. For the ACCC, it was an important decision because it closed a loophole that otherwise could have existed. There was a concern that if the court did not find Mr. Keir responsible for those posts, others would use their friends or aliases to post false testimonials, and they would do that out of reach of the regulator or the courts otherwise. So what's happened since then? Well, there's been 2 Advertising Standards Board decisions which has applied the case. The Advertising Standards Board applies the National Advertisers Code of Ethics. I think it's an industrial body, it's really a form of self-regulation. But in relation to 2 Facebook marketing campaigns, one was a Victoria Bitter marketing campaign using Facebook. The board determined that a Facebook page is a marketing tool which the advertiser has a reasonable degree of control over. And applying Justice Finkelstein's thinking said that the Advertising Standards Board code therefore applied to Facebook pages. The other Facebook marketing board determination is a Smirnoff vodka one, but I won't go into the details of those. The other recent development is the ACCC's publication of guidelines for the use of social media. The clear message, I won't go into them in any detail either, but the clear message is be vigilant. And the question there is just how vigilant do you need to be? The ACCC says that the degree of vigilance will depend on the size of the company and the number of followers you have. In Mr. Keir's case, he was a sole director and the company's Facebook page was really his. What about BHP Billiton or Coca-Cola? The ACCC also says establish some house rules and block users who don't abide by them. But those, the application of the Allergy Pathway case to professional standards, and the publication of the ACCC guidelines is really as far as we've come in the 2 years since the allergy pathway decision was handed down. What I'm waiting to see is the next case that comes along and applies Justice Finkelstein's reasoning. And what would be interesting is if liability was contested on the basis of knowledge, so that sort of first hurdle, I didn't know that it was on my Facebook page. But perhaps I'll leave it there.